feeling any sort of, for yourself, pressure to get the investigation finished soon before the summer conventions?
No, and the only reason I hesitate is in any investigation of intense public interest, whether it involves a public figure, involves some horrific crime. San Bernardino is a great example. We feel a great sense of urgency to do it well and to do it promptly.
All right, that was the FBI director, James Comey, talking about the investigation into Hillary's email server in the mom-and-pop shop bathroom closet and how he wants to get it right, and I don't blame him for saying exactly that. But is this now going to impact this race at all? Will we know before the convention? I'd like to know if we'd know before Election Day, which was the next obvious question, which sadly was not asked. Horace Cooper, legal commentator and partner at Monument Communications. Danielle McLaughlin, constitutional expert, attorney, here to discuss Comey, sort of his walk back on the aggressive investigation. I thought we were hearing, Danielle, that he was going to be interviewing her within days and interviewing Cheryl Mills and Felipe Reigns and Uma Abedin in days, and then all of a sudden he seemed to back it off and slow the whole thing down. What do you think's going on?
Well, I agree with you, Sean. I think we all thought that these interviews would be coming within days, if not weeks. And I think what he said about the investigation proceeding well and promptly is important. He wants to do both, and he won't sacrifice the well for the promptly. I think this may have implications for her going forward. It's certainly problematic for her now. Although what's interesting, I think, is her unfavorability versus favorability have remained pretty constant. We're looking at about 40% favorable, maybe to 55% unfavorable. What I think is helping her, at least politically, is the vast amount of knowledge that she has and the sort of clear indication to the voting public that even though this is going on, she is the most qualified person for the job of president of the United States.
But the unfavorables are high, you're right, yeah. But I think even a worse number for her is consistently 65% of Americans do not find her honest and trustworthy.
I know. I agree with you. I think it's really a problem for her. She's talked a lot about that. She's talked about the fact that she's not a natural politician. But certainly the fact that there is an ongoing FBI investigation into her activities as Secretary of State as it relates to her email and servers is a huge problem for her politically and potentially legally. And we can get to the legal points. No question that this is a huge cloud over her campaign, and it remains to be seen the extent to which it will continue to be over the coming months.
Yeah. What's your take on it, Horace?
Well, the observation that she's not a natural politician is like saying Barack Obama doesn't really love her Constitution. I'm really actually kind of concerned that there's not political pressure being put on FBI Director Comey to slow walk this. And it isn't so much. I mean, the evidence is pretty overwhelming, the publicly available evidence. I am not privy to any of the conversations that are being had under oath or with the FBI. But the public information that we already have is fairly overwhelming. And it would do a very big disservice to the American people to allow them to be forced to make a choice between candidates and then after the fact say, oh, well, we're going to have Inauguration Day, and then we're going to have Grand Jury Day in the same week. That is actually the opposite of what a good, helpful legal system should be trying to operate under. Yeah. And when he said he was going to try to do it in a fair and timely way, I think that means it should be sooner rather than later.
It sounds like, I think the word slow walk really captures the feeling I got listening to Comey here. I mean, at this point, we were told, and reports and leaks and press clippings all talked about how they had finished the actual investigation into the email server and expanded the investigation into whether or not the Clinton Foundation was doing a little bit of pay to play and whether or not there was some corruption there as well. And now all of a sudden we went from, the interviews are imminent, the FBI director would personally handle it, to, it could happen at any time, not necessarily before the conventions. I'd like to know don't you think the American people need to know the answer to this before Election Day in November?
I mean, I certainly do. I agree with Horace, and I think this hurts Secretary Clinton more than it helps her. The idea that this goes on and on. You know, Director Comey is a Republican appointee, of course. Looking through his history, he's
No. Wait.
He's a law and order guy.
He is a law and order guy.
Yeah, absolutely.
And if you want to call that Republican to be law and order, I guess I'll accept it.
No, and I'm absolutely not making the connection. I'm not making the connection at all. I believe that he is a fine public servant, and he is a law and order guy. You know, back in 2004, he actually, threatened to resign if the Department of Justice finding about wiretapping being without a warrant not being constitutional. You know, he's a law and order. He's a constitutional guy. This is in no way meant to be a derogation of his abilities or what he's doing here. But the idea that there's somehow forces at play that are pushing this out on behalf of Clinton makes no sense, because this only hurts her the longer it goes on, I think.
No, wait. I gotta push back on that. First of all, from just a case management and investigation perspective, there's a phrase that everyone should understand. It's called the statute of limitations. Now, she has not served at any point as Secretary of State during the second part of Barack Obama's administration. That means 5 years is coming up pretty rapidly. That also means there are witnesses and there are other participants to what occurred who may find they no longer have to speak truthfully anymore because their own personal legal jeopardy has been
let me ask this, Horace, because I have a lot of respect for two friends of mine, Joe DeGeneva and Victoria Tunsing, and they're very well connected, and they both are convinced that a grand jury has already been convened.
Sir. Oh, yes, sir.
You believe that?
Here's why. I'm positive of it. You can't actually hold testimony just with oral representations made to FBI directors or FBI agents. I want to correct myself. The testimony that has been provided and that is being provided, even when protection is provided, immunization agreements are reached, that information is only available to be presented to a grand jury. Of course, there is a grand jury that is already in existence.
You think a grand jury has been impaneled?
Yes.
But do you believe that grand jury will eventually hear from Hillary, Uma, Cheryl Mills, and Felipe Reigns?
I believe that Mrs. Clinton is going to tell the public that she is more than happy to participate in any conversations with the grand jury, and her lawyers are going to tell them she refuses. And since that part of the process is secret, we won't likely be told until later that she refused to come before them. But it is her legal right to do so, and they can't compel her.
Don't you think, based on everything that we do know, I mean, remember, the law, the standard as it relates to top secret or secret access program information is very clear. Just the mishandling of such information, and I would argue putting it on a server of a mom and pop shop in a bathroom closet is mishandling it and then denying and lying about it. I mean, every single top secret special access program classified information piece would be an individual felony in and of itself, would it not?
This would be a list of violations that you would have a hard time competing in a 12 or 13-page book. All of the various instances, plus there are these additional parties that facilitated this process. And the statute in question doesn't require a knowingly and intentional. It is a reckless standard, one of the few felonies that you are allowed to have as a basis for a conviction if you engage in reckless behavior. How can you actively allow the secreting of private information? Maybe they tried to remove headers, eliminate particular dates, but give essentially classified information to her over a private server and think that would be consistent with the protection of that data. There are very, very likely those classified individuals' sources that have been harmed or abrogated precisely because.
Well, don't we know from the Inspector General of the intelligence community that it came out dozens and dozens and dozens of emails that were classified found on her server, which she originally denied. And then she said marked classified. Then we found out some of the specifics, including satellite photos, North Korea's nuclear program, among other things. Then we found out that, yes, there were other top secret, beyond top secret classification. That's where the special access program classification comes in, which is above top secret. Doesn't that tell us that it was mishandled? Doesn't that mean that our methods may have been disclosed? Isn't it likely that the Chinese, the Russians, maybe the Iranians hacked into her email server?
Very likely.
All right.
Very likely.
I mean,
And this isn't like
you
the
don't know.
Sandy
I
Berger
mean,
case.
you don't know.
Well, we do know that they've been able to break into our government system. Why wouldn't they be able to find the Secretary of State's emails?
And I don't disagree with you, Sean, and I think what is important here also is to think about the context of what was going on. Of the 1,800 emails that were post hoc marked classified, which is not a basis upon which you can indict the post hoc marking of classification. So there's all sorts of layers of administrative and other sort of interagency scuffles that are going on. That's important. The other thing is that Secretary Clinton wrote about 5% of the emails that have been found to have contained classified information. There are 300 other authors within other parts of the federal government. Since only 2014 has it been not disallowed under the federal laws for a Secretary of State or someone working within state to not have a private email. There is a systemic problem here. There is a systemic security problem as the Department of State has moved very, very slowly into the 21st century. I think there are some problems for Clinton, but she is not alone, and I think we need to see this in the context of the broader problems that are systemic in state.
Well, I want to focus in on the actual issues at hand. General Petraeus was not allowed to say that all of the emails that he gave his colleague access to, even though she had a classified protection, but she didn't have the classified authority to see these particular ones, not all of them were sensitive. That wasn't a defense that he was allowed to do. And I wanted to reference Sandy Berger. We're not here dealing with you can get away with being sloppy when you carry out private documents, slip down in your pants. We have a negligence standard in this case, and sloppy actually can send you to jail. As Sean just pointed out, you can't have photos from satellite images that you're forwarding back and forth, and even if by some chance they were not marked classified, you'd have to be a moron to not know that you can't send those forward. And if that's going to be her defense, then I think she should get out of the presidential race altogether.
Well, to speak to your point on General Petraeus, and I think this is an important case because it cabins in, from a prosecutorial discretion perspective, the extent to which Clinton's intent will be viewed. General Petraeus, as you know, knowingly took top secret information, transferred it into his own.
All right, listen. This was so minor. Number one, the woman involved, Paula Broadwell, had clearance for most of this. Number two, you're talking about the guy's calendar of events. I mean, it was not anywhere near the level or scale of what we're talking about here.
This is also a guy who invited journalists into classified briefings because he understood that there was there was some benefit to him to do that.
But that is not. This is. She institutionalized the breaking the law to do this. But I've got to let you both go. I don't mean to be rude.